From the daily list under heading for judgment, item 1, FA 124 of 2023.
This appeal is allowed.
Your information on case outside the list. On second appeal, Chief Justice has heard on 30th January 2026. Judgment has been reserved. We have informed the learned executive court as well that judgment is reserved by your lordship in this matter. But what has happened in the incident is now the Nazir and the bailiff of the court.
I can't do anything about it.
Issued matters are better for execution of writ of delivery of possession.
The order is reserved.
The applicant will be erected matters from the premises. You have informed about the order before the executing court.
The fact that the judgment is reserved, it is reflecting in the.
It is there in the order also. They have informed the they are proceeding with the matter. They will issue the letter for executing the date of delivery.
There is nothing on record before me what they are doing.
There is an IM pending with the lordship.
IM must be pending prior to this, no?
Prior to this also they have issued the letter for executing.
From the daily list under heading for fresh filing, item 2, VA 1851 of 2026.
And 3 persons are named in the first information. This petitioner is not named in the first information report, and subsequently he has been made an accused on the basis of the conditional statement of the court. Several other accused persons having similar allegations, however, they have been allowed bail in this case. Save except the conditional statement of co-accused, there is no other evidence and detailed matters against me.
You were found at the place of occurrence during the relevant time. In the CDR report, you are found at the place of occurrence. There were certain unnamed accused also.
Yes, but 3 persons are named.
That's right. But the CDR report says that you are found at the place of occurrence during the time.
That is on the basis of the condition.
No, that is not on the basis of condition. CDR is not on the basis of condition.
CDR, I am resident of that nearby place, Mallards. And whereas the other persons were having similar allegations, that I got the copies of the orders, Mallards of the Mallards.
Heard the learned counsel appearing on
These
behalf
are the
of
orders, Mallards.
the learned counsel for the petitioner has submitted that the petitioner has been not named in the FIR and his name has come in confessional statement and he has been falsely implicated in this case. The petition is in custody since?
He is in custody since 15 September 2025. Investigation
The
has been
petitioner
completed.
is in custody since 15/9/2025. The counsel for the state has opposed the prayer. After hearing the learned counsel for the parties, it appears that there is serious allegation against named as well as unnamed accused persons in the FIR.
At least 6 persons.
Just a moment.
Several persons
Just a
were-
moment.
I have to say something.
Who has been granted? No, be the honest.
Several other persons have several allegations. They have been also granted bail merits because only on the basis of the
Counsel for the petition has submitted that though the co-accused namely Sagar Kumar and Sanjay Kumar has been enlarged on bail.
similar allegation merits and who have got also several cases merits. That is also mentioned in order granting bail to them. Especially Shankar Kumar Mathur, he has got several incidents, but he has been granted bail merits. Then the other accused persons who have also got the 3 antecedents. I am accused in 2 other cases.
The learned and Sunu Pawan has also been enlarged on bail.
Sagar Kumar having 3 antecedents. Shankar Kumar Mathur has been allowed bail and received several criminal cases. Delhi also वहाँ पे देखते हैं उसके क्या it's one of the cases that what happened in those cases and also like so usually are the real manipulated or those cases are pending in this because only the cases of the conviction are more than 6 months it has been requested. First time we have reports.
The learned counsel for the petition has also submitted that the co-accused persons, namely Sagar Kumar and Sanjay Kumar Gangu, also had criminal antecedents, but since there was no recovery from their possession, they have been enlarged on bail. This means that the case of the petitioner is on similar footing. The learned counsel for the state has opposed the bail and has submitted that it reflects from the improved order itself that the CDR of the mobile number of the petitioner,
Against him also there is
from the CDR of the mobile number of the petitioner was present at the place of occurrence of the present case. And he also has 3 more criminal cases of similar nature. After hearing the learned counsel for the parties and considering the serious nature of allegation, and that during investigation, through the CDR report, through the CDR of mobile number, the petitioner was said to be present at the place of occurrence. The FIR is against some known and some unknown accused persons, and the petitioner is having 3 more criminal antecedents. This court is not inclined to enlarge the petitioner on bail.
Item 3, BA 1876 of 2026. Item 4, BA 1926 of 2026.
Yes, petitioner.
FIR registered under section 376 As per the FIR, it has been alleged that the petitioner has, on the pretext of marriage, the petitioner has committed rape upon the informant victim since 2020. There was a love affair between both of them.
Petitioner is a married person.
Now,
He is in police department. And there is also an allegation that there was abortion
Both
3
are-
times.
that is allegation is there, but no section is there. But FIR was registered under section only 376 not 330 of the Act.
And you have been threatening her also.
So that is the allegation, madam. The fact is that the both are the major matter and since 2020 they are in relation. Now matter has been also compromised between both the party members. 183 BLS of the victim, the reported member, has come in the case very
They have compromised.
now matter has been
Compoundable.
नहीं, but my lord,
Just see how powerful you are.
since my lord both are major my lord, there was a consent between both.
Compromise का तो बात ही नहीं है. Compoundable है तो करिए compromise.
नहीं compromise हम लगाए नहीं है as per the instruction I have sent.
Call for case type. And state to file a counter affidavit. Post this case on 9th of April.
item 5 DA 2010/2026.
I have also in the registered under section 305P of the BS University. Of the FIR, I will not against unknown person. And was on the confessional statement of the co-accused, the name of petitioner has come into the light. And also accept the confessional statement, there is nothing against the petitioner. And was the tractor which has been also alleged, has been recovered. I am stated in also bail petition in paragraph in paragraph 11, the High Court also case diary 126, where the tractor has been recovered from the behind of the Sagar Kumar house of Sagar. And Lordship on the confession of three Lordship accused persons, Lordship the same has been recovered. Lordship all the Lordship three persons are Lordship the co-accused, Lordship that is
Since when are you in custody? Since when are you in custody?
Lordship 9/12 Lordship it is 9/12 9/12
आपका कोई एंटीसीडेंट है?
न ये हुजूर है, उससे हुजूर इसमें डिमांड है, हम ऑलरेडी लिखे हो, उसी से डिमांड किया गया।
वो क्या चीज का केस? वो क्या चीज का केस?
वो हुजूर वो भी चोरी का एक केस था, उसी से हुजूर हमको रिमांड किया, लेकिन इस केस में हुजूर एक्सेप्ट द कन्फेशनल स्टेटमेंट देयर इज नथिंग अगेंस्ट द petitioner, neither has been recovered from the house or from the possession of petitioners except Lordship confessional statement, there is nothing against this petitioner. और 9/12 से हुजूर हम कस्टडी में हैं, और हुजूर ट्रैक्टर जो रिकवरी हुआ सागर कुमार के घर के पीछे से, वो हुजूर उसका भी हम लिखे हुए हैं कि 3 आदमी, मेरे कन्फेशन से भी रिकवरी नहीं हुआ, 3 आदमी हुजूर जो है 3 को co-accused persons, उनका हुजूर हम लिखे हुए हैं। 11 में ही हुजूर हम लिखे हुए हैं, दिगंबर कुमार और विशाल जब कन्फेशन से हुजूर जो है ट्रैक्टर की रिकवरी हुआ और सागर कुमार के घर के पीछे से, मेरा न कन्फेशन से रिकवरी हुआ है, न मेरे पोजीशन से रिकवरी हुआ है, मेरा घर से रिकवरी हुआ है, एक्सेप्ट कन्फेशनल स्टेटमेंट देयर इज नथिंग अगेंस्ट दिस।
क्या बोलिए?
Lordship, मॉडर्न डाटा के अनुसार इनका मोबाइल बैलेंस और ऑपरेंस पे पाया गया है।
तो चारों का है,
चारों का है।
केस डायरी में चारों का है, जिसमें कन्फेशन पे 2 आदमी के कन्फेशन से रिकवरी, न मेरा कन्फेशन से रिकवरी है, न मेरे पोजीशन से है, न मेरे घर से रिकवरी। और सिर्फ कन्फेशनल स्टेटमेंट के अलावा देयर इज नथिंग अगेंस्ट दिस petition।
कॉल कम डेटा में आप वहीं पर हैं?
हाँ, हुजूर
On the place of
घर हुजूर एरिया वही है, घर वही है, तो एरिया चूंकि वही है, देयरफॉर व्हाट्स दिस हैज कम, ये नहीं कि हम दूसरा जगह, तो ओनली ऑन एक्सेप्ट द लॉस ऑफ कन्फेशनल स्टेटमेंट देयर इज नथिंग अगेंस्ट मी, न मेरे घर पोजीशन से रिकवरी है, न मेरे घर से रिकवरी है, और 2 जो को-accused हैं दिगंबर कुमार और विशाल, उनके कन्फेशन से सागर कुमार के घर से पीछे से रिकवरी, न मेरा कन्फेशन से रिकवरी है, न मेरे पोजीशन से रिकवरी है, देयर इज नथिंग अगेंस्ट।
प्लेस ऑफ अकरेंस क्या है? प्लेस ऑफ अकरेंस क्या है?
प्लेस ऑफ अकरेंस जो है एज पर एफआईआर न्यूज़
राजरप्पा
जी रोहित छोटकी पोना गांव का नाम है रजक।
प्लेस ऑफ अकरेंस राजरप्पा है।
जी
आप कहाँ के रहने वाले?
हाँ,
आप बोलते वहीं रहते पड़ोस में।
प्लेस ऑफ रेजिस हाँ वो जो जहाँ से वो जो चूंकि
आप बोले वहीं रहते हैं आप पड़ोस में, इसीलिए आपका मोबाइल फोन वहाँ पाया।
रेसिडेंस तो सॉरी सिंदूर है, लेकिन मुझे जो है कि सिर्फ जो है कि वही है, इसके अलावा और कुछ नहीं है मेरे लिस्ट में, देयर इज नथिंग अगेंस्ट।
इसलिए सोच के बोला।
हाँ एक मुझे सिर्फ जो है कि मेरा जो है कन्फेशन, क्योंकि मेरा कन्फेशन से मुझे रिकवरी है, ना मेरे पोजीशन से रिकवरी है, जो दिगंबर कुमार और विशाल राज जो लोग को एक्यूज है, उनके कन्फेशन से सागर कुमार ने घर से पीछे से और अगेंस्ट द कन्फेशनल स्टेटमेंट हमारे अगेंस्ट में कुछ नहीं।
PA number 2010/2026. Or the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the petition has been implicated in this case on the basis of confession statement of co-accused. And he has also submitted that the vehicle has been recovered from the backside of the house of
सागर कुमार
Sagar Kumar. Caesar list का
सीरियल लिस्ट नहीं हमको मिला था, उसको लगाया नहीं। तो लिखे हैं अपना स्टेटमेंट में, हम पैराग्राफ 11 में
and he has referred to paragraph 11 of the bail application. He has submitted that there is confession statement of all the co-accused persons, including the petitioner, and the petitioner is in custody since 9/12/2025 and has one criminal antecedent. The learned counsel for the state has opposed the prayer and has submitted that the mobile number of the petitioner was found at the place of occurrence in the call down data.
अगर सभी का रिजेक्शन हो रहा है
After hearing the learned counsel for the parties, it appears that the petitioner has been made accused on the confession statement and the vehicle was recovered from
behind Pakka House of
behind the Pakka house of
Sagar.
Sagar Kumar as stated in the bail application, and the petitioner is in custody since 9/12/2025. The petitioner is adequate to get charged for
Item 6, DA 2011/2026.
होगा लिस्ट 2025 के केसेस में मेरा नाम संदिग्ध के लिस्ट में आया। पेज नंबर 15 में, पेज नंबर 16 में संदिग्ध के लिस्ट में पिटिशनर का नाम मेरा नाम आया कुमार, पिता मालूम लिखा हुआ क्लियर लिखा हुआ सेकंड सबसे बड़ी बात है कि
संदिग्ध का लिस्ट किसको बोलते हैं? FIR में नाम है ना?
FIR में कन्फेशनल स्टेटमेंट है जिसमें पिटिशनर का प्रॉपर नाम कुणाल लेकिन पिता भी नहीं नाम। सेकंड चीज है कि सुधीर कुमार के कन्फेशनल स्टेटमेंट में ये बात बयान दर्ज हुआ है कि सुधीर कुमार और कुणाल मतलब हम दोनों सासाराम से किसी महिला के पास से, जिसको भाभी जी के नाम से जाना जाता था, ब्राउन शुगर माने का काम करते थे। लेकिन ये FIR रजिस्टर हुआ है हुजूर 2025 में और अभी तक के इन्वेस्टिगेशन में मेरे खिलाफ कोई भी चीज नहीं है, कुछ भी चीज बरामद नहीं है, केवल एक कन्फेशनल स्टेटमेंट के अलावा
आपके पास से कोई रिकवरी
कुछ भी नहीं, केवल एक कन्फेशनल स्टेटमेंट है जो सुधीर कुमार के द्वारा दिया गया था और इसके तहत में मेरा नाम पिटीशन में आया, FIR में आया और और उसके अलावा कुछ भी चीज अभी तक नहीं हुआ। मार्च 2025 में रजिस्टर हुआ और आज मार्च लगभग 1 साल तक इन्वेस्टिगेशन में कुछ भी चीज नहीं आया मेरे पास। जुडिशियल कस्टडी में 28 जनवरी से
कोई एंटीसीडेंट है? एंटीसीडेंट
कोई एंटीसीडेंट नहीं।
कहाँ लिखी है?
भावनगर से
कहाँ
गिरफ्तार।
लिखी है?
हाँ?
कहाँ लिखी है? नहीं लिखे हैं ना? Call for case diary, counter affidavit and criminal antecedent report of the petition. State कौन है इसमें? कौन है इसमें state?
Mr. Shailendra Kumar Tiwari का नाम है।
Since the counsel for the state is absent, let a copy of this order be communicated to the office of Claimant Advocate General to ensure compliance. Post this case on 9th of April. खोज रहे थे,
Items
हमको नहीं मिला, घर पे भी नहीं मिला, इसलिए आपको पूछा। इसलिए अपने अंदाज से मत बोला करिए, कोई भी चीज लिखा जाएगा तो आपका रॉन्ग सबमिशन हो जाएगा।
Item 7 DA 2012 of 2026.
Fire against Section 310 of the matter allegation that the number 6 person entered the bank and entered the bank manor as and
आपका तो सीसीटीवी फुटेज में भी आइडेंटिफिकेशन है और क्या चाहिए?
nothing has been recovered.
रिकवरी का क्या है? सीसीटीवी फुटेज में आपका है आइडेंटिफिकेशन, व्हाट एल्स इज रिक्वायर्ड? कितना पैसा लूट लिए हैं?
1 करोड़ 64
Fire against Section 1 matter.
अब हाजीपुर के रहने वाले हैं ना? कहाँ के रहने वाले हैं? हाजीपुर, वैशाली।
This one. Yes, sir.
For the learned counsel appearing on behalf of the parties. Sorry, not required. The counsel for the petitioner submits that the petitioner is in custody since
27 October 25.
27,
October
10,
25.
25,
No criminal action.
and the petitioner has no criminal antecedent and he has been falsely implicated in this case. And there is no recovery from the possession of it. The learned counsel for the opposite party has opposed the prayer and has submitted that the petitioner along with others have looted away rupees 1,64,25,250 along with gold packets weighing 2200 grams and rupees 3,05,000, and he has been seen over the CCTV footage, and upon his confession statement there is recovery from the house of Anand Raj. Considering the serious nature of allegation and that the petitioner had been identified in CCTV footage, this court is not inclined to enlarge the petitioner on bail instruction.
Item 6
Non-appearance.
item number CD contract. Item number 6 में paragraph number 19 में mention है there is no criminal entity.
अब काउंटर आना है। हम खोज रहे थे, हमको नहीं मिला, आप भी खोजे, आपको भी नहीं लिखा, कुछ ऐसे जगह लिखा हुआ है जो नजर नहीं पड़ी। कोई बात नहीं, आने दीजिए। आने दीजिए, NDPS है, सीरियस ऑफेंस है भाई, आने दीजिए, क्रिमिनल एंटीसीडेंट केस डायरी आने दीजिए। अगर आप जो बोल रहे हैं वो सही है तो आपको जरूर देंगे।
Item 8 BA 2023 of 2026.
Case has been registered under section 310 to 311 of BNS.
So, what is the fresh ground?
Fresh ground is custody is more than is now 18 months, 1.5 years, and all the co-accused have been granted bail, charges have been framed, evidence has also been examined.
क्या state है evidence का? How many witnesses have been examined?
3 have been examined.
Out of?
I don't know the case diary. 3 have been examined and 1 has identified me in TIP. One of the co-accused was also identified in TIP has been granted bail and extradited. And one more accused has been granted bail last month. It's a so everyone has been granted bail. Was not named in case and
जब आपका ये 16/9/2005 को जब कोएक्यूज का बेल हुआ था, तो आपका रिजेक्शन ऑर्डर प्लेस है?
yes, page number annexure 1 page 11.
Page number 17. Your bail application was rejected earlier.
Yes.
कोएक्यूज के बेल के समय आपका रिजेक्शन ऑर्डर प्लेस हुआ था कोर्ट के पास?
After that,
नहीं हुआ था ना? ऐसे ही होता है। BA number 2023 of 2026. Heard the learned counsel appearing on behalf of the parties. Counsel for the petitioner submits that the bail application of the petitioner has been rejected twice by this court. Once in BA number 506 of 25 on 24/1/25, and then in BA number 9421 of 2025 on 31/10/2025. He submits that co-accused has been granted bail by the same bench who has rejected the case of the petitioner on 16/9/2025 in BA number 7938 of 2025, and another co-accused in BA number 9207 of 2025 has been granted bail on 16/10/2025. The learned counsel for the state has opposed the prayer and has submitted that the petitioner has been identified in TIP and there is also recovery from the possession of the petitioner, and the case of the petitioner is not on similar footing as that of the other co-accused who have been enlarged. So this the counsel for the petitioner, and so far as the co-accused are concerned, there has been no recovery from them. To this, the counsel for the petitioner has submitted that the petitioner is in custody since
15/9/2024, 15 September 2024.
15/9/2024, and 3 witnesses have been examined. However, he is not
None has supported.
However, he is not aware as to how many total witnesses are there. After hearing the learned counsel of the parties and considering the serious nature of allegation and the fact that the case of bail application of the petitioner has been rejected twice earlier, this court is not inclined to enlarge the petitioner on bail. However, the learned counsel, the state is directed to ensure prompt production of witnesses before the court. The counsel for the state is directed to communicate this order to the director of prosecution and to the superintendent of police of the concerned district to ensure compliance. Communicate.
Item 9 BA 2027 of 2026.
Date 26 and 35 on the confession of the petitioner, one pistol has been recovered from the central judge. That is the allegation. As I read the allegation 1 at page 23, you just see the middle lines.
इनके हिसाब से एक one gets.
There are criminal antecedents of similar
Yes.
very serious nature.
3 cases are 8 to 18
Yes.
It was also
It is mentioned in the interview.
I have also मैंने एक 2018 का है, एक आपका MMRDA का है, third is there.
The learned counsel for the petitioner submits that the petitioner is in custody since 4/1/2026 and it is alleged that one arms have been recovered upon the confession statement of the petitioner on his pointing. Counsel for the state has opposed the claim and has submitted that the petitioner has several criminal antecedents of similar nature, of serious nature, and the arms have been recovered on the pointing of the petitioner from bush. After hearing the learned counsel for the parties and considering the criminal antecedent of the petitioner and that the arms have been recovered and the pointing out of the petitioner, this court is not inclined to enlarge the petitioner on bail and
It's one antecedent is of the year 2018. Other जो है MMRDA.
उसमें अब नहीं, there are three antecedents.
I want also
Arms Act. Arms Act.
हर एक काम
कोई बात
नहीं, एक काम से क्या है, तीन दिन ये वाली माया आने माया ने एक काम से
We have seen it. We have seen one arm.
हाँ, yes, एक काम से क्या, I'm not denying that.
एक 386 का है.
एक 386 का, that is of the year 2018.
उसमें acquittal हो गया?
हाँ, उसमें वो
Acquittal हो गया?
और एक आपका MMR, that is
Item 10 BA 2033 of
It is already
2026.
Yes, it is.
382, that is 385. The case of a house that will be.
How much is your custody?
Huh?
How much is your custody?
Custody 23/12/2025. In this case,
Any TIP?
no TAP, nothing.
No antecedent?
No antecedent. Because one thing, he has been first arrested in connection with the Narayanpur PS. 3 days he was detained in Narayanpur PS. Then he was remanded. Everything on the basis of secret information of the police. And it has been alleged that after his confession leading to recovery of the cultivated pistol from the bushes. No articles has been recovered. And 27 arms act is not there against me. Or 35 arms act. 3 police is saying he has been apprehended from Karmata railway station. My case is that he has been detained in Narayanpur PS for 3 days and thereafter he has been remanded in this case on 23/10/2025. But what is according to me, entire diary or anywhere, no case number of Narayanpur PS has been mentioned.
Are you an accused in Narayanpur PS?
No, I am not. I am not an accused, but 3 days I have been detained.
From where will I get this?
This is a submission that has been made by the land in the improved order.
That I understand. But
But
from
that
where
is the
will
only
you get
thing, madam. 7 except that no other information I have.
any antecedent?
Antecedent, madam, according to me, there is no other antecedent because that also requires a lordship pleases and call for the antecedent. Because admittedly, no TIP has been held, madam.
No TIP has been held.
No TIP has been held.
Counsel for the state is directed to file a counter affidavit in this case, along with the criminal antecedent of the petitioner.
Because they are saying that all has come.
The learned counsel for the petitioner has also submitted that the informant has claimed that he would be able to identify the accused persons upon seeing them, but no TIP has been held. the counter affidavit should specifically state about the fear. Post this case on 19.
Item
FIR में बोलता है इंफॉर्मेंट के हम आइडेंटिफाई कर सकते हैं तो आप टीआईपी क्यों नहीं कराएं? मतलब दिस इज वेरी स्ट्रेंज।
एक में भी टीआईपी नहीं होता।
क्यों नहीं करवाते? तो बेसिक चीजें जानबूझ के नहीं करवाते हैं, फॉल्सली इंडिकेट करके जेल में रखे रहेंगे। कन्विक्शन हो जाएगा क्या इनका? आर्म्स एक्ट का तो केस भी नहीं बना है। फिर
Item 11 BA 2034 of 2026.
Matter relates to NDPS Act matters, and according to the allegations, under 2 persons were apprehended by the police, and according to the allegation, from the position of this petitioner, 1.22 grams of brown sugar, that is the small quantity matters, said to be recovered from the position of this petitioner.
do you have any antecedent?
No antecedent. And just now matters from the coordinate bench, the co-accused has been granted bail. Against whom matter there was criminal antecedent.
क्रिमिनल एंटीसीडेंट होने से हम
नहीं,
नहीं
मेरा नहीं।
देंगे, दूसरे को दिए हैं तो हम नहीं। हाँ, आई डोंट वांट टू से एनीथिंग, वो उस पे क्या है नहीं है, आई कैन
In the
नॉट।
present case, there is no criminal.
वेयर हैव यू स्टेटेड दैट
That
यू
is
आर नो
seen
एंटीसीडेंट?
as stated.
Is it small quantity?
Yes, 250 grams and above into the commercial.
For the learned counsel agreeing on behalf of the parties. The learned counsel for the petitioner has submitted that. How much gram? कितना मिला है? बस
1.22 grams.
1.22 grams. कहाँ लिखा? Where is it?
Paragraph 10.
नहीं, इंप्यूट ऑर्डर में लिखा होगा ना?
हाँ, इंप्यूट ऑर्डर में भी लिखा है। It's running page 29, my lords may come to. About 5 lines from the top, my lords. Present accused stroke petitioners who were involved in sale and purchase of brown sugar, and total 2.08 grams brown sugar has been recovered from them. And individually 1.2, that is this.
ऐसे सेग्रीगेट नहीं होता है,
One.
ऐसे सेग्रीगेट नहीं होता है, जॉइंट पोजीशन से है तो सेग्रीगेशन नहीं होता है।
Funds. Individually 1.22, jointly it is 2.0.
The learned counsel for the petitioner has submitted that, as per the allegation, 2.08 grams of brown sugar has been recovered from the two co-accused.
These two accused.
From the two accused persons. And as per the allegation, while the police was on patrolling, the petitioners, the accused persons, including the petitioner, were trying to run away and they were apprehended. The summit said the petitioner has no criminal antecedents and the recovery is of small quantity. He has referred to paragraph number 16 of the bail application. The counsel for the state has opposed the prayer. After hearing the learned counsel for the parties and considering the fact that small quantity of brown sugar is alleged to have been recovered from the petitioner and the petitioner is said to have no criminal antecedent, the petitioner is directed to be enlarged on bail. The learned trial court shall call for the criminal antecedent of the report of the petitioner, and if any antecedent is found, he shall not be enlarged from now.
Objection.
आपका स्टेटमेंट है, अगर कोई भी एंटीसीडेंट मिलेगा तो आप रिलीज नहीं होंगे, बात खत्म, काउंटर नहीं है, कुछ नहीं, दे विल कॉल फॉर एन एंटीसीडेंट एंड देन रिलीज आफ्टर वेरीफाइंग योर एंटीसीडेंट.
Objection. वो एक चीज़ है,
उससे हम नहीं,
ठीक.
वो ऑर्डर नहीं है मेरे पास.
Item 12, DA 2039 of 2026.
Arrest statement is no kind of offense is kept in dwelling house. As per the first information report, एक मैरिज में शादी हो रहा था, इंफॉर्मेंट की शादी का, और वहाँ पे चोरी हुआ एक नेकलेस एंड 12,000 कैश. नेकलेस का वैल्यू वाज 1,67,000 यूएस डॉलर. मेरा नाम आया है स्टेट रिकॉर्डिंग इन्वेस्टिगेशन में, जो रजिस्टर की सर्व इन्वेस्टिगेशन में आया है. पिटिशनर उसके हस्बैंड बार-बार उस एरिया में दिखे गए उस सीसीटीवी फुटेज के हिसाब से. Apart from that, there is a impugn order shows criminal incident against the petitioner. But I have specifically made that statement for wrong criminal incident दिखा के petitioner. It was registered against the husband of the petitioner. सिर्फ petitioner के केस में यहाँ पे कोई implicate कर दे रहे हैं. And in this case, और petitioner के साथ petitioner happens to be a lady, उनके साथ दो बच्चे भी custody में. As about 3 to 5 years.
Can you claim that you are not an accused in this case?
In this case,
In Sindri PS case number 50 or 25, you said that it is wrong recording.
if wrong,
Where have you stated?
evidence not right. The petitioner criminal incident referred in the case that do not relates to the petitioner pertain solely for the husband. The petitioner has only one criminal case, namely Sindri case number 50. This is the Sindri case number 50. Only
Sindri case number 50 तो है
that's so
ना?
that's so minor. Yes,
This is
that-
not Sindri PS
no,
case number.
That's so minor. Never.
That is a separate thing. You say that गलत लिख दिए हैं ऑर्डर, तो ऐसा नहीं है. एक एंटीसीडेंट तो है ना आपका, whatever be the nature of it, but there is one antecedent.
Yes.
So you admit to that extent,
And no submission to nursing allowed.
which is relating to a dispute with the neighbor.
Once para 11 times she is lady and custody with 2 minor children. That means custody.
There is no recovery from you.
No. And हमको सिर्फ देखा कि नियर बाय. नियर बाय
कब से कस्टडी?
22 जनवरी.
स्टैट्यूट हो गया होगा? स्टैट्यूट हो गया?
ये फैशन. That was also recorded. इसलिए हम
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the allegation against the petitioner is that she was involved in stealing away one Kangan set worth rupees 1,67,808 and cash of rupees 12,000 from the room of a resort where marriage was to be solemnized. He submits that though the husband of the petitioner has number of criminal antecedents, but so far as the petitioner is concerned, she has only one criminal antecedent which relates to some fight
neighborhood fights.
with the neighbor. The learned counsel has further submitted that the petitioner has 2 minor children, one baby boy aged 2.5 years and one baby girl aged 3.5 years, and she is in judicial custody since 22/1/2026. He submits that there is no recovery from the possession. Counsel for the state has opposed the prayer. After hearing the learned counsel for the parties and considering the submission that there is no recovery from the possession of the petitioner, and that the petitioner has 2 minor children to be taken care of. The petitioner is adequate to be enlarged.
Under heading for admission, item 13, BA 10786 of 2025.
In this stage of trial was proper. In this case, allegation as against the petitioner is that he has purchased the stolen property. It's a gold strip. We having an accident.
The stolen article has not been recovered.
No, that has not been recovered, that has not been added. Not only on the basis of confession he has been demanded.
But some gold item has been recovered.
He's the gold
It's
strip.
a gold
Yes.
the gold article तो
Yes.
उसका इतना गला के बना दिया होगा.
Yes. Was not identified.
Only on the basis of confession demanded in one or another cases.
कब से custody?
The
Custody.
state में है 39/2025.
चार्जशीट तो हो गया होगा.
Plus, within 3 months.
Evidence tested. For the learned counsel pleading on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 13/9/2025, and the petitioner is a goldsmith, and it is alleged that the stolen article was given to the petitioner, and he has used the same for making other gold ornaments, which has been seized
From his shop,
from his shop,
along with the other jewelries.
along with other jewelry. Submits that except confession statement of the accused, there is nothing against the petition. As per the status report, the charge has been filed on 22/26, and it is at the stage of evidence, and out of 5 charge sheet witnesses, none have been examined so far. Counsel for the state has opposed the affair. However, the said submissions are not in dispute. After hearing the learned counsel for the parties and considering the fact that the name of the petitioner has come in the confession statement of the accused, and
EIP has also.
petitioner TIP क्या होगा इसका?
वही अगर कोई चोरी में इन्वॉल्व नहीं है that time of this.
गोल्ड चेन को गला के दूसरा चेन बना लिया, उसका क्या TIP?
The allegation एक चोरी करने का है. Main allegation वो है.
And the
चोरी करने
petitioner
में-
is in custody since 13/9/2025. The petitioner is directed to be enlarged on bail. The state is directed to ensure prompt production of witnesses. Counsel for the state is directed to communicate this order to the concerned authority.
Item 14, BA 11079 of 2025.
Yes.
Last occasion is very much case was under section 305 and 112 of the AS. Maximum sentence of in both the sentences are may extend to 7 years. It is alleged that 7 thieves have committed theft in TRW workshop and stolen away
आपका CCTV footage में आप देखो.
some rest co-accused persons.
केस डायरी देख के बोलो.
Lordship,
केस डायरी देख के भेजो.
thank you, Lordship. मैक्सिमम सेंटेंस जो है दैट इज मे एक्सटेंड टू 7 years. चार्जशीट इन्वेस्टिगेशन कंप्लीट हो गया है, चार्जशीट हो गया है. देयर इज नो नीड ऑफ फर्दर custodial trial or custodial interrogation.
Maximum sentence is 10 years.
No, maximum sentence may extend to 7 years. And charge sheet has already, investigation has been completed, charge sheet has been submitted, charges have been framed.
Antecedent?
इससे पहले नहीं था, लेकिन बाद में केस में रिमांड में I clearly stated in para 16 also in my petition itself. इसके
बाद में जिस केस में रिमांड हुए हैं वो केस इसके पहले का है कि बाद का?
इसके पहले का बेल हो गया उस पे
तो एंटीसीडेंट तो है ना, वो तो
हाँ
एंटीसीडेंट
नहीं,
होगा
इसलिए
ना।
हम लिखे स्पेसिफिकली आई स्टेटेड, उसमें हम नेम नहीं थे, फिर बाद में इसके बेसिस पे हुआ क्लियरली स्टेटेड इन para 16 of West.
आपके पास से कोई रिकवरी नहीं?
As per the inquiry order, you must have
Recovery
the
है।
recovery of the stolen property.
सबके लिए लिखा हुआ है, पिटिशनर्स 5 लोग का.
आपका नाम है दीपक महली।
दीपक
आपके पास से अलग से रिकवरी
लिखा हुआ
तो केस डायरी की बात। ऊपर चेक कर लीजिए, है ना? Heard the learned counsel appearing on behalf of the parties.
उसके अलावा लॉर्डशिप दो चीज पे ये कह रहे थे कि इन द लाइट ऑफ अनफेयर लॉर्डशिप इसमें आ जाएगा क्लास ए में कि 7 साल से तक का सजा है, इन्वेस्टिगेशन हैज बीन कंप्लीटेड, चार्जशीट हैज बीन सबमिटेड, चार्जेस हैव बीन पेड. कहते 7 टन हम स्क्रैप चोरी करके ले गए, कैसे ले गए कुछ नहीं है. दैट हैज बीन कंसीडर्ड इन द केस ऑफ गोइंग यूज्ड बाय योर लॉर्डशिप.
ऐसा कोई लॉ अभी तक नहीं बना है कि 7 साल से कम सजा हो तो आपको बेल दे ही देना।
तो बिना सीधा प्रिवेंटिव डिटेंशन
रिकवरी है, इसमें प्रिवेंटिव डिटेंशन नहीं है, रिकवरी है आपके पास से। सीसीटीवी फुटेज है, ट्राई नहीं कर रहे हम लोग।
ट्राई का योर स्टेप सिंपली सबमिटिंग कि जब सारा चीज हो गया, देयर इज नो नीड ऑफ कस्टोडियल ट्रायल.
नहीं, देयर इज अ नीड।
प्राइवेट बेसिस आपके केस करेंगे 7 साल का मैक्सिमम सजा है, उनका कस्टडी इज 25 725 और से.
For the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the petitioner is in custody since
25 725.
25/7/25, and the maximum punishment which can be imposed for the alleged offence against the petitioner is up to 7 years.
Up to 7 years.
He submits that the petition has been falsely implicated in this case, and co-accused and 4 co-accused persons have been enlarged on bail in PA number 11512 of 2025, by order dated 19th of February 2026. The learned counsel, are you for the state?
The JUVNL.
The learned counsel for the JUVNL has opposed the prayer and has submitted that public property has been stolen away, and as per the case diary, a part of the stolen property has been recovered from the possession of the petitioner, and petitioner also has one more criminal antecedent, and he was identified on the CCTV footage with respect to the place of offence. After hearing the learned counsel for the
एक चीज
parties.
से जोड़ दिया जाता है नीचे कि I was not put on for test identification
Directly.
and charge had already been framed.
After hearing the learned counsel for the parties and considering the fact that there is recovery from the petitioner, and he has also been identified in the CCTV footage and has one criminal antecedent, this court is not inclined to enlarge the petitioner on bail. The case of the petitioner does not fall on similar footings as that of the other co-accused persons who have been enlarged on bail.
Item 15 BA 11209 of 2025.
While the petitioner under the RKPS case number 218 of 2024, it is stated that on his confessional statement, one country-made pistol, cartridges, and a magazine was recovered from the other co-accused person who have been granted bail, that is at page 26 annexed. The only allegation against him is that on his confessional statement, this was recovered.
From the possession of another person.
Another person. And he
You are
was
already an accused in the other case.
in that case, I voluntarily surrendered. Thereafter, I was taken into remand, and it is stated that on his statement, those articles were recovered from the persons who have been granted.
It is alleged that this weapon was used for the commission of offence in that same
In that case,
आप कब से custody में?
he voluntarily surrendered on 14/7/25. Charge sheet had already been submitted.
Any antecedent apart from that case?
That case, there is no.
इसके अलावा तो कोई नहीं. Third, the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner was taken into custody in connection with another case, and while in custody, on the confession of the petitioner, the arms had been recovered from the possession of the co-accused. It is alleged that the seized arms was used in the commission of the offence for which the petitioner was earlier taken into custody. He submits that apart from these two cases, there is no other criminal case against the petitioner. Counsel for the opposite party has opposed the plea for bail. However, the aforesaid facts submitted by the petitioner is not in dispute. आप लिखे हैं कि आपका कोई criminal antecedent नहीं है इसके अलावा.
That I have stated.
The learned counsel, on the point of criminal antecedent, the learned counsel has referred to paragraph 15.
At paragraph number 5 of the supplementary affidavit.
Oh, sorry. At paragraph number 5 of the supplementary affidavit. He has also submitted that the petition has been convicted for offence under section 302 of IPC, but he has been enlarged on bail. यही है ना?
That I have given the order of.
वो जो जिसमें आपको रिमांड किया था उसका केस नंबर क्या है?
218.
200.
That is 208, your lordship.
After hearing the learned counsel for the parties and considering the fact that the charge sheet has already been submitted so far as the present case is concerned, and the petitioner is in custody since 14/7/2025, and the alleged recovery is from the possession of co-accused. The petitioner is likely to be enlarged on bail.
Item 16, DA.11.16.09 of 2025.
Under various section 9 section 103, that is one of the section generic. IR was lodged against 5 named accused person and 5 unknown person. So for the first information report is
So
concerned,
it is direct allegation against him.
Lord, there is the 6 eyewitness. 5 eyewitness, they have seen the occurrence, they have not stated anything about this petitioner, that this petitioner stepped that.
No, there is statement in the case diary.
Yes, Lord.
In the case diary, the statement has come.
Yes, not condition. One person, after 2.5 months, he was examined by the police, and he has stated that the both persons were
No.
not injured.
The injured person has given a statement.
Yes, Lord. I was also
Actually,
injured.
he was in the hospital.
I am also injured. I was also
He
injured.
sustained grievous injury.
Yes, Lord.
And one person was killed on the spot.
Yes, spot. Lord, I was also injured. I was also admitted in hospital. Lord, can they see the 5 eyewitness who have stated that Lord, all the persons, Sabi medical, all the persons, Lord, that assaulted the deceased, and thereafter he never
127.
Later on, Lord, the one person, Lord, that is the Anil Pandit, he was Lord, examined 2.5 months after the occurrence.
That's right.
And he has stated that he has stated the name of 2 persons. This petitioner is not Mukul Jana. I am in custody on 25/11/2024. And charge sheet submitted. 5 eyewitness. There was nothing stated.
दो हजार 24 से आप कस्टडी में हैं।
एक एंटीसीडेंट भी है।
चार्ज शीट सबमिटेड भी है।
एंटीसीडेंट भी है।
एक तो है 94 में ये आया हुआ है, ये 414 420 का है, नॉट द
NDPS एक्ट भी है, जेजे एक्ट भी है।
हाँ, NDPS and जेजे धारा 414 420 भारतीय दंड विधान है, NDPS है 17 जेजे।
कस्टडी आप पिटीशन में कहाँ लिखे हैं? हमको आपका कस्टडी नहीं पता चला।
कस्टडी पारा 5 में है। पिटिशनर और स्टेट एंड लेटर रिमांडेड, ये तो कस्टडी में है।
आप अपना कस्टडी इस केस से बताइए, कहाँ कब से हैं आप कस्टडी में?
हम 10/11/2024 को हॉस्पिटल में थे, कोर्ट में हमको प्रोड्यूस किया गया है 25/11/2024, इसीलिए इम्प्यून ऑर्डर में 25/11/2024 लिखा है। काइंडली सी द इम्प्यून ऑर्डर।
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 24/11/2025. 2024 लिखा है। 24 लिखा है। 25/11/2024. He submits that a number of persons had jointly assaulted the deceased and so far as the injured person is concerned, his statement has been recorded after 1.5 months.
2.5.
After 2.5 months from the date of occurrence. The learned counsel for the petitioner has submitted that co-accused persons have been enlarged on bail in BA number 4 co-accused persons have been enlarged on bail in BA number 6461 of 25 by the order dated 8/9/2025 and BA number 4389 of 2025 by the order dated 8/9/2025. The counsel for the state has opposed the prayer and has submitted that the injured victim who suffered grievous injuries has specifically alleged against the petitioner, and he is not only an injured victim but also an eyewitness to the offence. After hearing the learned counsel for the parties and considering the aforesaid submission and that there is direct allegation against the petitioner, this court is not inclined to enlarge the petitioner on bail. So far as the bail of the co-accused persons is concerned, they were given bail on the submission that the specific allegation was against the present petitioner and one Mithu Yadav. And therefore the case of the petitioner stands on defeat.
Observation.
Full observation.
At this
Counsel for the state is directed to ensure prompt production of witnesses. The counsel for the state is directed to communicate this order to the director of prosecution and the superintendent of police of the concerned district. They ensure compliance.
Item 17 PA 11663 of 2025.
Yes, petitioner. बहुत जबरदस्त तरीके से यूज किया है.
3,087.
Amount is not important.
Only one person has been a victim. I am disclosing every fact. What is Lord, only one victim, 3,087 rupees. He has been not apart from that, Lord, there is nothing. And the co-accused bail has been rejected, Lord. That also I am saying, Lord, by coordinate bench at this stage, Lord. This is the fact is there. Against them there were several victims. Against this petitioner there is only one victim, para 67.
I have 57 directly.
67.
One criminal.
Yes, that I will state in my paragraph.
Direct link है. Your device is
Only, yes, para 67 I am saying.
only one victim is not important.
Lord,
The important is what is important is that you are involved in this.
Yes, Lord.
थोड़ा दिन रहिए अपने ठीक हो जाए.
At this
थोड़ा दिन ऐसे लोगों से दूर रहेंगे अपने ठीक.
At this stage कर दिया.
At this stage it is.
Yes,
It is always at this stage.
yes, Lord. Because Lord, there is a Lord in this case, Lord. If your Lordship may allow me to, I have stated everything before your Lordship.
Yes,
But if only 1, 2, 3 things, Lord. The petitioner, Lord, was not even present at the place of occurrence. He has been made accused, Lord, in this case. Both the seizure list witness, they are the police constables, Lord. And nobody has supported, Lord. And that mobile has been, Lord, that SIM and mobile has been planted by the police to implicate the police. Well, apart from this, Lord, they are very, he is from good family. He has recently, he has been made accused in this case, Lord.
Heard the learned counsel opinion on behalf of the parties. The learned counsel for the petitioner has submitted that the petitioner has been falsely implicated in this case and he is in custody since
4/8/2025.
4/8/2025. He submits that the mobile and the SIM have been implanted upon the petitioner to make an allegation by the police to make an allegation of cyber offence. Counsel for the state has opposed the prayer and has submitted that the petitioner also has criminal antecedent of similar nature.
Yes, that I have
And
stated.
in the case diary, the use of the mobile and the SIM by the petitioner has been given in details. He has also submitted that victim has also come forward to support the allegation against the petitioner. With this, the counsel for the petitioner has submitted that there is only one victim. After hearing the learned counsel for the parties and considering the allegations and also that the petitioner has one criminal antecedent and victim has also supported the case of the petitioner, this court is not inclined to enlarge the petitioner on bail and rejected.
Item 18 PA 11931 of 2025.
Offenses under section 3096 20.10.03.1 of the BMS and 27 of arms. In this case also, this petitioner is not named in the FIR. Name of the petitioner has transpired on the basis of confessional statement of other co-accused. That co-accused has been granted bail by the coordinate bench of this honorable court. Petitioner is in custody from 4/9/25. Charge sheet has been submitted. In this case, lots of counter affidavit has been filed. It has come in the counter affidavit that 6 criminal antecedent against this petitioner. However, from the diary it appears that 2-3 cases has been registered after this FIR, and जहाँ भी नाम नहीं आता है उनका नाम इसमें DT.16 is the FIR also.
FIR पढ़िए.
मास्टर साहब ने आवेदन है कि मैं स्वयं वर्तमान में स्वयं पुलिस की रहने वाली हूँ. पूर्व में एक बार हम मुखिया नहीं है, इसके बाद मुखिया मेरे पति रहे थे. वर्तमान में हम लोग CSP अपने नए घर किला टाड़ नहीं चलाते हैं, उसमें सीमेंट छर्री का भी व्यापार करते हैं. दिनांक 2/6/25 को हम सुबह अपने बच्चों के साथ अपना मायके पथरिया रामगढ़ गई थी. हमारा पति घर पर ही थे. समय लगभग 11:45 बजे मेरा भतीजा शक्ति हासदा फोन किए कि चाचा महेंद्र टुडू को अज्ञात व्यक्ति द्वारा गोली मार दी है, जिसे गांव के लोग उठाकर इलाज हेतु सरैया हाट ले जा रहे हैं. प्राप्त सूचना के आधार पर हम अपने मायके से परिवार के साथ ग्राम पथरिया से अस्पताल के लिए प्रस्थान किया. सरैया हाट अस्पताल मेरे पहुंचने से पहले डॉक्टर द्वारा बेहतर इलाज हेतु देवघर अस्पताल रेफर कर दिया गया. तब हम पुनः सरैया हाट से देवघर के लिए निकले. देवघर मेरे पहुंचने से पहले ही डॉक्टर द्वारा मेरे पति को दुर्गापुर के लिए रेफर कर दिया.
आपको क्या बोलना है?
There are antecedents and the motorcycle which was left by this petitioner, that too was a stolen one, and the person whose motorcycle was stolen, he had filed a case against for the theft of his motorcycle, and he produced the original papers of his motorcycle.
The stolen motorcycle was also recovered from the possession of the petitioner.
While fleeing away, he left the motorcycle. This petitioner left the motorcycle and he ran away.
There is recovery of arms from the petitioner.
There are 3 cartridges and 1 pistol also. And Kachuk, the person who has been granted bail by this coordinate bench, he has got 1 antecedent, and this petitioner has got 6 antecedents.
All the learned counsel is pleading on behalf of the parties. The learned counsel for the petitioner has submitted that the petitioner is in custody since 4/9/25, and he has been falsely implicated in this case. The petitioner is not named in the FIR, and his name has come in the confession statement of the co-accused. The learned counsel for the state has opposed the prayer and has submitted that the petitioner has as many as 6 criminal antecedents, and there is recovery of arms from the possession of the petitioner upon his confession statement.
In the counter affidavit is has been written that recovery of arms is from the
Mumtaz Ansari.
who has been granted bail.
Mumtaz Ansari के पास है.
इनके पास से नहीं है recovery of
इनके
arms.
पास है. the other side of us.
उनका TIP हुआ? TIP हो गया? क्यों नहीं कर रहा? क्यों नहीं कर रहा? अब बोलते यही चोरी का मोटरसाइकिल से भागे थे, TIP भी करवाएंगे. How will you link it?
Motorcycle was seized while when the petitioner left the motorcycle.
Who has identified the petitioner? He is not named in the FIR. Who has identified the petitioner? That it was this petitioner only who ran away.
On confession of co-accusation.
ये सब जानबूझ के ही होता है. इसमें तो कोई डाउट ही नहीं लग रहा. इस तरह से हम देखते हैं किसी केस में TIP नहीं होता. क्यों नहीं होता? तो पता तो करिए ना आखिर TIP क्यों नहीं होता. आप लोग पूछते नहीं है कि TIP क्यों नहीं कराया. ये बंदा जेल में है तो क्यों नहीं इसका TIP कराया. बताइए. केस भी खुद ही लगाते हैं और एक्यूटल का तैयारी भी खुद ही करते हैं. इनके सबमिशन में लिखिएगा. The counsel for the petitioner has also submitted that the petitioner has not been put in TIP and there has been no recovery from the petitioner. He has referred to the counter affidavit and submits that there is recovery of arms from the co-accused, as mentioned in paragraph 55 of the case diary. She has also submitted that so far as the co-accused who has been enlarged on bail, he has how many criminal antecedents? One antecedent, and the petitioner has as many as 6 criminal antecedents. To which the counsel for the petitioner has submitted that a few cases were registered after the present case. Yeah? Yes. After hearing the learned counsel for the parties and considering the fact that the petitioner is neither named in the FIR nor has been put on TIP, nor there is any recovery from the petitioner, and apparently except confession statement, nothing could be pointed out by the side of the state. and one co-accused has been enlarged on bail. The petitioner is likely to be enlarged on bail.
Item 19, BA 12026 of 2025.
Yes.
No specific allegation मेरे ऊपर है लोग से कस्टडी since 14 और 25 जेल में है कोई एंटीसिडेंट नहीं है
नेचर ऑफ इंजरी क्या है? ग्रीवियस
all accused persons
There is no specific allegation against you in the FIR.
No, sir.
है ना?
No specific allegation.
Read the FIR. Sorry?
निवेदन पूर्वक करना है कि मैं भोला है पिता स्वर्गीय योगी है काम महात्मा जिला पूजा का निवासी हूँ मुझे अपने ससुराल पक्ष में जमीन मिला है जिस पर मैं शांतिपूर्ण रूप से स्वपरिवार पशुभास को खेती करके आ रहा हूँ दिनांक 2/12/24 को सुबह
क्या बोलना है स्टेट?
मान्यता है
लेकिन इनके ऊपर कोई स्पेसिफिक तो नहीं है।
इसके ऊपर स्पेसिफिक नहीं है लेकिन वैसे ऊपर इनको को मारा गया इधर प्रीवियस
कस्टडी भी तो 14/7/25 से है, चार्जशीट तो हो गया होगा आपका
14/7/25
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that though the petitioner is named in the FIR, but there is genuine and omnibus allegation on all the co-accused. He submits that admittedly there is land dispute between the parties, and the petitioner has no criminal antecedent. He is in custody since 14/7/2025. He has referred to the paragraph 17 of the bail application that he has no criminal antecedent. The learned counsel for the state has opposed the prayer. The learned counsel has also submitted that some of the co-accused persons had enlarged on anticipatory bail in ABA number 4/22 of 2025, and one co-accused has been enlarged on bail in B number 11939 of 2025. Counsel for the state has opposed the prayer and has submitted that the victim has sustained grievous injuries on vital part of the body. After hearing the learned counsel for the parties and considering the fact that there are general and omnibus allegation on the accused persons, including the petitioner, and co-accused who is similarly situated has been enlarged on bail by coordinate bench. and the petitioner is already in custody since 14/7/2025. The petitioner is directed to bail out on bail.
Item 20, BA-12034 of 2025.
This is the case of dowry death. Petitioner is mother-in-law of the deceased. There is general anonymous allegation against this petitioner. There is no any overt act against this petitioner, and similarly situated and male accused. Husband of the deceased has already been acquitted in separate trial.
तो आप कहाँ? बेबे यू
हम सरेंडर हम समय
आपके घर में आपकी बहू मर जाए और आप गए,
सरेंडर नहीं किए थे।
कोई बात नहीं, एब्सकॉन्ड कर रहे थे तभी ना कुछ स्प्लिट हुआ ट्रायल, ऐसे तो नहीं स्प्लिट हुआ होगा ट्रायल।
82, 83
कोई बात नहीं, लेकिन यू वर नॉट अवेलेबल ना।
82, 80
आप ये तो ऐसा केस नहीं है ना कि आपको पता ही नहीं है कि आपके अगेंस्ट है केस। नवीन एब्सकॉन्डिंग, हस्बैंड का एक्यूटल का आपको कोई बेनिफिट नहीं।
एफआईआर में कोई एलिगेशन नहीं है।
एफआईआर से चलेगा?
कोई एलिगेशन नहीं
आपके घर में आपकी बहू मर गई, आप बोलते हैं एफआईआर से चलेगा?
डॉरी डिमांड भी नहीं है, ना किसी तरह का टॉर्चर का एलिगेशन हमारे अगेंस्ट में। जो भी है हस्बैंड का है और हस्बैंड की भाभी के अगेंस्ट एफआईआर है।
अभी आपको बेल नहीं दे सकते,
लेडी है,
इसीलिए तो और नहीं दे सकते। लेडी का एब्सकॉन्ड करना तो और सीरियस बात है। If a lady is absconding, it becomes very serious. Mother-in-law absconding, शर्म नहीं आता mother-in-law?
घर में ही रह रही थी, पुलिस अरेस्ट नहीं कर रही थी, क्या करें?
बहुत पावरफुल है आप।
पावरफुल क्या रहेगा?
पुलिस अरेस्ट नहीं कर रही। बहुत एक्यूज थे, खाली 3 ही पर चार्जशीट हुआ।
कोई एलिगेशन ही नहीं है।
कोई बात
एफआईआर में कुछ
कोई बात
नहीं है।
कुछ देर बाद आइए।
कोई हुजूर एफआईआर हम पढ़ देते हैं, किसी तरह का भी कोई एलिगेशन होगा
उससे नहीं चलेगा ना।
डिमांड का, टॉर्चर का, मिसबिहेव का कुछ नहीं है इसके अगेंस्ट में। एक शब्द नहीं लिखा गया है मदर के अगेंस्ट में, एक शब्द।
स्ट्रैंगुलेशन से डेथ हुआ है घर के अंदर, आपके प्रेजेंस।
तो ये हल्ला कर रही थी कि सांप काटने से हो गया।
ये हल्ला कर
घर में बहू मर जाए तो मदर इन लॉ से ज्यादा कोई और जिम्मेवार नहीं होता। When we see in the society in general, और mother in law absconding is all the more serious. PA number 12024. After some argument, when this court was not inclined to enlarge the petitioner on bail, the counsel for the petitioner seeks permission to withdraw the bail application, which is dismissed as before.
साइन कर लीजिए, साइन करा लीजिए। Item 21, BA-12188 of 2025.
Litigation under section 310(2) and 311, litigation of deputy law. Litigation will require that 12 persons enter into the house of the Purohit and committed deputy law. Committed deputy of 3 lakhs.
पुरोहित के यहाँ में हम डकैती कर रहे हैं
Litigation is
और कोई नहीं मिला।
in course of investigation, one of the co-accused, namely Mukesh Kiro, was apprehended by the police force, and he confessed the name of the several other co-accused persons, including this prisoner also. And other co-accused persons with the similar allegations have been granted bail by the coordinated names, and prisoner have no criminal antecedent also. And
CBI में तो आप कहा
CDR, it is coming that his CDR.
Professional statement leading to recoveries there also.
कहाँ
Paragraph
बताइए?
76 and 77 of the case diary.
Leading to recoveries
On the basis of professional statement.
leading to recovery of rupees 50,000 belong to this petitioner also. That is the money which has been recovered, which belongs to this petitioner also.
अभियुक्त सदानंद साहू के निशानदेही पर एक सैमसंग मोबाइल फोन 15,230 रुपया एवं 20 रुपए का नोट नगद एक स्कूटी एवं एक तलवार जब्त किया गया।
that talwar was used during course of Dakati also.
Talwar is the weapon which has not, this petitioner had not been put on TIP laws.
कौन सा पैरा बताइए?
Para 76 and 77.
The money which has been recovered is belonged to this petitioner also. Meaning that money has belonged to this petitioner also. And Talwar which is a general weapon, it is found to be every one house now.
अरे घर में तलवार रहता है क्या?
तलवार इस रामनवमी में तो हर घर में हम लोग पूजा भी करते हैं लॉर्डशिप भी है
रामनवमी में कहाँ तलवार यूज होता है? नहीं देखे हैं अभी तक। डंडा यूज होता है, डंडा यूज होता है,
डंडा तलवार भाला सब भी कुछ यूज होता है, पूजा होता है।
सनी
Similarly situated कोई कुछ पर्सन have been granted
antecedent है इनका?
no antecedent, no antecedent that कोई कुछ has been granted bail lordship similar situated।
कब से हैं जेल में?
ये 16/10/2025 से।
Still be recovered.
Heard the learned counsel pleading on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely indicated in this case. His name has come in the confession statement of the accused. And the recovered articles from the petitioner are cash and common articles. Cash to the extent of 15,000. Submits that the petition has no criminal antecedent
not been put on TIP
and has not been put on TIP. Submits that similarly situated co-accused persons have been enlarged on bail in DA number 207 of 2026 and DA number 11747 of 2025. The learned counsel for the opposite party has opposed the prayer and has submitted that there is recovery of cash and one mobile and one sword from the possession of the petitioner. But it is not in dispute that the petitioner does not have any criminal antecedent and he is in custody since 16/10/25. Charge sheet has been submitted.
no criminal antecedent.
After hearing the learned counsel for the parties and considering the reported submissions and the fact that the similarly situated co-accused persons have been enlarged on bail, the petitioner is likely to be nominated.
Item 22, BA 1219 of 2025.
Because the main section is 307 apart from other sections. A petitioner is not named in the first information. As per the prosecution case, the informant, he has gone for group study at the house of his cousin brother. In the night, they went out for taking snacks. There they started discussing about a theft of battery from a temple. In the meantime, it was revealed that one Shahid was involved in the alleged theft. Then Shahid was called. He said that one Gullu alias Gulraj, he was involved in the theft. Thereafter, Gullu was called for there, and thereafter the altercation took place. In the meantime, Shahid, he called his brother, who came along with 8 to 10 unknown persons. They all assaulted the informant and his cousin brother, due to which they sustained injuries. Now the petitioner has been named later on the basis of confession of Gulraj Minox, and this Gulraj has been granted bail by this honorable court. We have annexed the order. Apart from that, the brother of the Shahid, namely Sajid Elias Barak Huskers, he has also been enlarged on bail by this honorable court. Measure 2 is the order. Now this petitioner is in custody since 25/9/2025. And though the charge sheet has been submitted, but before submission of charge sheet, the petitioner was never put on test identification parade.
Any eyewitness?
Lords,
Any eyewitness?
Lords, the informant and his brother, the victims
Eyewitness
are...
to the occurrence was identified, nothing. Any statement of the witnesses was
No,
identified?
No, save and except the confession, there is absolutely no evidence against the petitioner. The victim has also not named the two victims, they have also not named the petitioner, and the petitioner was never been put on test identification.
About क्या बोलना है?
Lord, one more fact I would like to say. There are antecedents, Lord, but in all cases have been granted bail by this honorable court.
How many antecedents?
Lord, as per the Tune order, 4 antecedents.
क्या बोल रहे? डायरी तो यहाँ पर है। आप क्यों नहीं देख रहे? डायरी देख लीजिए। कोई विटनेस इनको सपोर्ट किया है, कोई नाम दिया है, देख लीजिए। सिर्फ एंटीसीडेंट के आधार पर किसी का इस तरह के एलिगेशन पे बेल नहीं डकैती अकैती का एंटीसीडेंट समझ में आता है या हायर्ड क्रिमिनल का एंटीसीडेंट समझ में आता है। तो इस तरह के केसेस में एंटीसीडेंट के आधार पर बेल नहीं रिजेक्ट करेंगे। ठीक है, देख लीजिए 10 मिनट 12:30 1:45। ठीक है,
Item 23 DA1117 of 2026.
If permitted, I would like to read the FIR. FIR में मतलब इसी दौरान प्रसाद देवी के हाथ में स्थित हसुआ जो ये बबलू पांडे को दिया 16 और पेज 16
पढ़िए सर।
इसी दौरान प्रसाद देवी के हाथ में स्थित हसुआ,
देखिए एफआईआर पढ़ रहे ना तो आधा मत पढ़िए।
मेरे पिता की जान से माफी के संबंध में सविनय निवेदन है कि दीपक पांडे ग्राम कटिया थाना कुंडा जिला देवघर का निवासी हूँ। आज दिनांक 10/2/25 की शाम 4 बजे पिताजी अपने दुकान पर बैठे थे। उसी समय गांव के ही निरंजन पांडे, बबलू पांडे, राजन पांडे, प्रसन्न देवी साथ में है, अजय झा, आकाश झा, 8 लोग मेरे घर में आए। महावीर अखाड़ा के पास स्थित कमला निवास सभी एक मत होकर हरबे हथियार से लैस होकर दुकान के पास आए और पहले से बनाए प्लान के अनुसार निरंजन पांडे और रणधीर पांडे जो कि फरसा लेकर आए थे, दोनों ने बारी से निरंजन पांडे ने माथे पर फरसा से वार किया जिसमें माथा फट गया और रणधीर पांडे ने गले का वार करना चाहा, लेकिन पिता द्वारा हाथ से रोकने के क्रम में फरसा हाथ में लग गया जिससे हाथ कट गया। इतने में डब्लू पांडे जो डर लेकर आए थे पिता से शरीर पर वार किया जिससे पिताजी जमीन पर गिर गए। इतने में राजेंद्र पांडे जो टांगी लेकर आए थे उन्होंने पिता के पैरों को काटना चाहा, लेकिन पिता द्वारा पैरों को हटा लेने के कारण टांगी जमीन पर लग गई। इस दौरान प्रसन्न देवी के हाथ में स्थित हसुआ जो कि बबलू पांडे को दिया और बोली कि गला काट दो, अभी मना नहीं है। इतने में आकाश झा वापस करने पड़े। मैलोड हमारा प्रॉब्लम वही है, मैलोड बबलू पांडे का करके और आपस में बात हम लोग सभी मैलोड
मालूम हम बसे हुए हैं ननिहाल में और हमारी जमीन गई है देवघर एयरपोर्ट में एंड वी आर गेटिंग कंपनसेशन उसी को लेकर के प्रीवियस एनिमोसिटी है मैंने हाउ टू डिस्ट्रीब्यूट द मनी। और दूसरा माय लॉर्ड हमारा कहने का मतलब यह है कि किसी भी वेपन टाइप की बरामदगी नहीं है। देयर इज नो हसुआ, नो टांगी, नो रॉड, नो वेपन हैज बीन रिकवर्ड एट द स्पॉट बाय द पुलिस। और तीसरा माय लॉर्ड हमारा ये कहना है
विक्टिम है ना, चोट लगी है कि नहीं लगी है?
नहीं माय लॉर्ड, ऐसा माय लॉर्ड की तरफ
विक्टिम को चोट नहीं लगी है?
नहीं,
हॉस्पिटल वगैरह कोई नहीं गए हैं?
माय लॉर्ड द कॉज ऑफ द डेथ इज द हार्ड एंड ब्लंट ऑब्जेक्ट ऑन द हेड। हसुआ का कहीं जिक्र नहीं है माय लॉर्ड, हसुआ बराबर नहीं है, हसुआ का कट भी नहीं है। हसुआ गर्दन में मार दो, गर्दन में हसुआ का कट नहीं है माय लॉर्ड। अरे पूरे परिवार को फंसाया गया है, लेडीज जेंट्स सबको फंसाया गया एक साथ। अब मैटर है मनी का कंपनसेशन, हमारी जमीन के लिए देखा गया कोर्ट में और हम दो को बेल मिल चुका है मैडम। Cause of which is the hard and blunt object on the head.
क्या बोलना है आपको? All persons had assembled, but so far as any assault by the petitioner is concerned, it is not there. Although he was provoked to assault, but there is no allegation that he had assaulted. And the persons and similarly situated persons have been enlarged on bail. There is land dispute. कब से कस्टडी है आपका?
That's 325.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that admittedly there is land dispute between the informant party and the victim and the accused. And though the petitioner is named in the FIR and was provoked to assault the victim, but there is no allegation that he acted as per the provocation. The learned counsel submits that the co-accused persons, namely Rajiv Pandey and W. Pandey, have been enlarged on bail by the order dated 17/1/2026, passed in DA number 8205 of 25 and DA number 8596 of 2025. Counsel for the state has opposed the prayer and has submitted that all the accused persons have joined together for the purposes of assault, and ultimately the victim died of head injury. After hearing the learned counsel for the parties and considering the submissions and the fact that similarly situated co-accused persons have been enlarged on bail by coordinate bench, the petition is directed to be enlarged on bail. The petitioner shall not disturb the informant party in any manner, one of the conditions for bail.
Item 24, BA 313 of 2026.
The counsel for the petitioner submits that he does not want to press this bail application. Accordingly, this bail application is dismissed as not pressed.
Sign kar. Item 25, DA 765 of 2026.
Nobody appears on behalf of the petitioner. No adjournment request has been circulated. On 13/3/2026 also, nobody had appeared on behalf of the petitioner and the matter was posted today. Accordingly, this bail application is dismissed from non-proceeding. Counsel for the state.
Item 26.
अब आएंगे नहीं तो क्या करेंगे? 2 बार तो डेट दे दी, आज भी नहीं आए।
Item
आपको
20
समझ आया क्या किया? DFD कर।
Item 26, DA 892 of 2026.
This is under NDPS Act. And as per the case of the prosecution, the arrest data for those 2 persons who were going on a motorcycle. This petitioner and one Gulab Mir. And they were intercepted by the police. And from the dicky of the motorcycle, 2.52 kg of opium was recovered from the dicky of the motorcycle.
You were also riding the motorcycle.
I was not, I was with Gulab Mir. The motorcycle belongs to the brother of Gulab Mir. I was with him.
You were with him, no?
Yes.
In the motorcycle.
Yes, 2 persons were there. The quantity which is 2.5 kg up to intermediate quantity more than 2.5 kg is commercial quantity.
It is commercial.
Only 2.52 grams. 2 gram cover including the weight of the plastic in which it was kept.
प्लास्टिक का वजन हम लोग नहीं सुनेंगे। हम
2
लोग तो
ग्राम।
एक देखेंगे 2.52 kg।
हाँ।
2 ग्राम थोड़ी हुआ ये?
2 kg 252 ग्राम।
2 kg 52 ग्राम।
हाँ।
2.52 kg।
2.52 ग्राम।
2.5 kg।
2.5 kg is up to commercial quantity. Only 2 gram is excess. 2 gram is excess. And including the weight of the container. The weight of the container, even the plastic is consumed, must be more than 2 grams. Must be more than 2 grams. As per the counter affidavit part, he has got no criminal antecedents. No criminal antecedents. Only thing is that I was with the person. And the motorcycle belongs to brother of Bhola Bhuiya. It's not my motorcycle. It's not my motorcycle. And for this, he has remained in custody about 5 months, more than 5 months he has remained in custody. For 6 months he has remained in custody. 1st of October he is in custody. Counter affidavit has been filed. And in the counter affidavit paragraph 12, it is mentioned that he has got no criminal antecedents. The owner of the motorcycle is brother
You
of
were
Bhola Bhuiya.
apprehended on the spot, no?
Yes, 2 persons were going. I was on the motorcycle. I have no knowledge about the motorcycle. What was kept inside the dicky of the motorcycle? It is not the case that I was carrying any opium. It is not the case. There was having in bag containing the opium.
आपको क्या बोलूं?
कंसर्न पोजीशन से रिकवर हुआ है
That is
2.52 kg drug, which is a commercial quantity. Legal of 37 will come in.
including the weight, that is important marks. If the weight is detected by it, will come within the intermediate quantity, not the commercial quantity. 2 ग्राम प्लास्टिक का कंटेनर से ज्यादा ही उसका वजन। And the main person is Bhola Bhuiya, who was carrying it, because he had kept the.
This is meant for transportation of the contraband drug. They used to bring it from Putin and
There is no such allegation. There is nothing. Because he has got some
confession-
demand
in the confessional statement it has come, my lord, that
That is again बोला भी है
both have confessed the same thing, Lord.
तो कैसे confession होता है? You are also
And then, moreover, my lord, it is a recovery of 2.5 kg, Lord, it is commercial quantity, Lord.
After hearing the learned counsel for the petitioner has submitted that the petitioner was apprehended along with the co-accused with 2.52 kg opium and it became commercial quantity on account of the exceeding 2.5.
only 2 grams. Only 2
And
grams.
it exceeded only by 2 grams.
Only 2 grams, including the weight of the packet parts.
The learned counsel submits that the motorcycle in which the petitioner was riding belonged to the co-accused.
The brother of co-accused.
Belonged to the brother of co-accused, and the opium was recovered from the dicky of the motorcycle. The learned counsel has further submitted that the petitioner does not have any criminal antecedent. The learned counsel for the state has opposed the prayer and has submitted that the recovery is of commercial quantity and the petitioner and the co-accused were apprehended on the spot and in their presence the recovery was made.
That's one. My submissions were including the weight of its container that it must be more than 2 grams. If 2 grams is deducted, but it will come within the intermediate quantity.
The learned counsel has also submitted that if 2 grams is considered to be the weight of the container, then the actual recovery would be less than 2.5 kg and it would come under intermediate quantity. After hearing the counsel for the state has also submitted that the petitioner has also admitted his guilt during the confession statement. After hearing the learned counsel for the parties and considering the fact that there is recovery of 2.52 kg of opium from the dicky of the motorcycle in which the petitioner was riding with the co-accused. This court is not inclined to enlarge the petitioner on bail at this stage.
Item 27, BA 905 of 2026.
What is this IA for?
At that time, or that the
early hearing.
Yes. The co-accused having similar allegation have been allowed to in these cases. But the allegation relates to demand of living goods.
Any antecedent?
No. No, my as per my instructions are from the Opium order, it appears that there is no antecedent to have not mentioned all per ye key points. The petitioner has got too many criminal antecedents, he is in custody since 2012.
You have filed a counter affidavit? Counter affidavit antecedent to call for testimony. Post on 9th of April. 9th April.
Passover case, item 3, BA 1876 of 2026.
Petitioner absent. हाँ, कोई बात नहीं, आप हैं अदर साइड हैं, देख लिया अपना।
ये आइटम
आपने
22
देख लिया?
पासओवर केस।
हाँ? देख लिया कुछ है क्या है? ये आप ही का केस है 12191। You are not named in the FIR. You are in custody since 25/9/25. There is no TIP.
No.
And except
Confession,
confession
there is
statement, there is nothing. But
And person who has named this petitioner, he has been granted.
क्या नाम है उनका?
Woolridge.
गुलरेज।
His
उसका
order
ऑर्डर
is at page 15.
यही बोल के तो हुआ है कि को accused had fired.
Yes.
आपका
I'm not
नाम?
that person. नहीं.
को accused शाहिद।
हाँ, Shahid alias case. He is different person. It is apparent from the FIR.
Okay. क्या किए थे? आपकी बात समझ नहीं आई क्या? बताइए केस डायरी में क्या है इनके खिलाफ? ये क्या किए? कहाँ से बोल रहे हैं आप? इनका नाम FIR में है? तो फिर कौन विटनेस बोला है कि ये मारे हैं? ऐसा कोई विटनेस है? इनका TIP कराए हैं? तो क्या ग्राउंड पर कन्विक्शन करिएगा? हाँ? एंटीसीडेंट पर इनका कन्विक्शन हो जाएगा? TIP क्यों नहीं कराते हैं आप? ये मिस्टर पंकज कुमार, हर एक केस में TIP नहीं होता है, कुछ खास प्रॉब्लम है क्या TIP के साथ? हर एक केस में, in all the cases that I am coming across, किसी में TIP नहीं है। तो फिर कैसे, क्यों नहीं होता है TIP? खुद ही एक्यूज बनाते हैं, खुद ही एक्यूटल का ग्राउंड भी बनाते हैं, क्या चल क्या रहा है आपकी सरकार में?
On the lighter से.
हाँ बताइए।
अगर TIP करा देंगे
तो आइडेंटिफाई नहीं होगा।
हाँ, फाइनल फॉर्म सबमिट करना पड़ेगा। तो at
ये भी एक
least
प्रॉब्लम
person should face the rigors of trial. तो
TIP नहीं कराना तो सीरियस बात है। और अगर फाइनल फॉर्म जमा ही करना पड़ेगा तो जमा करना पड़ेगा, इसलिए क्यों सोचो? होना चाहिए ना। ऐसा नहीं है कि TIP में आइडेंटिफाई अगर नहीं हुआ तो आप ट्रायल नहीं कर सकते, ऐसा तो नहीं है। लेकिन TIP इज वेरी इंपॉर्टेंट। कोई केस नहीं, वेरी इंपॉर्टेंट।
Although it is not a substantive case, but it is a
बाद में
it leads to the investigation.
बाद में एक्यूटल करके अपनी बेइज्जती कराने से ज्यादा अच्छा है कि पहले फाइनल फॉर्म जमा करें।
It leads to coming to the actual conclusion, correct conclusion.
थोड़ा अपने डायरेक्टर प्रोसिक्यूशन से बोलिएगा कि हम लोग जानना चाह रहे हैं कि TIP क्यों नहीं कराते। नहीं तो किसी केस में जो है उनको हमको बुलाना पड़ेगा समझने के लिए कि TIP क्यों नहीं कराते, फिर उनको बोलना पड़ेगा कि आइडेंटिफिकेशन का कोई चांस नहीं है इसलिए हम TIP नहीं कराते।
ये तो फैक्ट समझ में आ जाएगा कि व्हाट इज द रीजन। अगर नहीं है, अगर प्लॉजिबल रीजन नहीं है तो लॉर्डशिप में पास एन ऑर्डर
बेल तो हम नहीं देंगे, लेकिन क्यों नहीं कराते?
Not for bail, if Lord, my Lord is considering for that
In this case, it was required, the TIP was required and it was not done.
अननोन है इतने
It is a
इतने
must.
विटनेसेस हैं
Yes.
पब्लिक लाइफ में हो रहा है तो टीआईपी तो होना चाहिए
एकदम जरूरी है. You cannot say it.
BA number 12191 of 2025. For the learned counsel appearing on behalf of the parties, the counsel for the petitioner submits that the petitioner is not named in the FIR and he has been in custody since 25/9/2025. No TIP has been held. He has also submitted that the confession statement of the name of the petitioner has come in the confession statement of Gulraj Khan, but he has been enlarged on bail by a coordinate bench of this court in BA number 7817 of 2024 on 25/11/2024. Similarly, another co-accused person, namely Faizan Qureshi, has also been enlarged on bail by in BA number 1543 of 25 dated by order dated 25/2/2025. The learned counsel for the state has submitted that petitioner has how many criminal antecedents? 4 criminal antecedents.
7 versus 7. Impugn order may be 4 each bench. And in the diary
7
also.
कहाँ से बोले? जब देखिए तो criminal antecedent कितना है इनकी डायरी पैरा नंबर बताइए. ये क्या है? 2 अलग-अलग डॉक्यूमेंट है क्या?
No, ये ICGS के पोर्टल से ये जो निकाला गया डिटेल्स from the ICGS. The details have been given. आजादपुर PS केस नंबर 522, मानको PS केस नंबर 2122, बेराम PS केस नंबर 624, ER 84924 ODT, मानको PS केस नंबर 176 of 25.
वो later this occurrences of 24 बाद का cases भी उसमें जोड़ दिया because ICJS का ही ये
All together 7 criminal cases against him.
8 है कौन सा केस है?
And some of them have been instituted after the present case.
66 20 25 वाला
है included 7 excluding this 7.
After hearing the learned counsel for the parties and considering the fact that the petitioner has not been named in the FIR and has also not been put on TIP. Victim बचा हुआ है ना? And the petitioner is in custody since 25/9/2025 and the co-accused named above have been enlarged on bail including Gulraj Khan, in whose confession statement the name of the petitioner has transpired. The petition is directed to be enlarged on bail. कल के लिए कल आ जाएगा सुबह सुबह.
Current hearing for final disposal, item 28, first appeal 37 of 2020.
The case is otherwise ready. Let him start it.
Your Lordship, can I start from the?
Yes, yes.
I'm bringing on now. Two-page list of date I have given. It would be easy if this is seen, if still
Where is the list of
preceded by the filing of the suit. This, all these events had occurred prior to filing of the suit. So these would be relevant because all these have been stated.
All these have come in the evidence?
Yes.
All these have come in the evidence? Whatever you have stated in your note has come in the evidence?
No dispute with regard to that. Only effect, what would be the effect, that is only in dispute.
Let's see.
So the first date is 10/1/1985. So other things may be skipped because this is my assertion. But the fact is that Jwala Prasad Singh had executed a sale deed in the name of Dr. Nutan Mills, who is the plaintiff, respondent, who is the original plaintiff, respondent. That fact is not in dispute.
Dr. Nutan Mills is the plaintiff.
Yes, original plaintiff. And we are on behalf of the defendant who is the appellant here. Sole defendant number 1. Now, one more important factor would be, if your Lordship would kindly see the boss title, Dr. Nutan Mills is the second wife of Sayyid Ishtiyaq Ali, and the defendant number 1 is the son of Ishtiyaq Ali from the first wife. So this is not in dispute, the relationship is not in dispute. So Ishtiyaq Ali, the defendant number 1 is the son from the first wife. And Ishtiyaq Ali married second marriage, conducted second marriage with Nutan Mills. This fact is not. This would be one of the relevant.
Sayyid Ishtiyaq Ali. He is defendant number 1. He is
No. The son of Sayyid Ishtiyaq Ali is Sayyid Mubin Ali, who is the son of Ishtiyaq Ali from the first one.
Okay. Just a moment. Defendant number 1 is son of
The son from the first one.
from first wife.
Yes. And Dr. Nutan Mills is the second wife.
Plaintiff is the second
And
wife.
the dispute essentially is between the stepson and stepmother.
Plaintiff is the second wife.
Yes. Now, original sale deed, it stands in the name of Dr. Nutan Mills. This fact also we cannot dispute. That sale deed was executed by one Jwala Prasad Singh in the name of Dr. Nutan Mills.
Name of the plaintiff.
Yes. Original plaintiff, now she died and she has now been substituted. She died during the pendency of
The suit has been decreed.
She died and she has already been substituted.
The suit has been decreed.
No. Strangely, what has happened, that the suit was filed by Nutan Mills. The suit was dismissed. We had filed, the defendant number 1 had filed a counter claim. That has also been dismissed. So, against the dismissal of the original suit, no appeal was filed by the Nutan Mills. And we have filed the appeal against the dismissal of our counter claim. So
What was the nature of your counter claim?
Now, what would be the effect of dismissal of the claim and non-filing of the appeal by Nutan Mills would be a very important factor in the instance. So only this may be kindly be seen. Now, admittedly, undisputably, the suit property was purchased in the name of Dr. Nutan Mills on 10/1/1985. But the second fact is important, that on 25/1985, Dr. Nutan means executed a deed of release in favor of Sayyid Istiaq Ali. That means her husband, which was registered, and she relinquished all her right, title, interest in the property in favor of Istiaq Ali, very clearly mentioning that this property, the entire consideration amount had been paid by Istiaq Ali, and she was only a binamidar, and therefore she was releasing all her rights, title, and interest in favor of Istiaq Ali. And another important factor would be this was prior to enforcement of the Benami Transaction Prohibition Act. Benami Transaction Prohibition Act came in the year 1988, and this deed of release was executed prior to that in the year 1985 itself. So the effect would be that once she acknowledged that the property, the entire consideration amount had been paid by Istiaq Ali, and she executes a registered deed of release in favor of Istiaq Ali, Istiaq Ali became the owner of the property by the deed of release. And then the second fact is that thereafter what happened, this is another suit. In 2004, Istiaq Ali and Nutan Mirs both filed a suit against the state of Jharkhand because it was mentioned that their vendor's name was mentioned as illegal possession since 1960. So they had filed a suit for declaration against the state of Jharkhand, and the same suit was registered as 24 of 2004, and the relief that was claimed in that suit was for a decree of declaration of title of plaintiff number 1 Sayyid Istiaq Ali over the suit. This fact is important. Now the relief itself claimed that it was for a decree for declaration of title of plaintiff number 1 Sayyid Istiaq Ali over the suit property, and then the said suit was dismissed by the original court, by the trial, on 8/3/2007. But on appeal, on 11/9/2007, the appeal was allowed, but the appeal was not allowed on title, on the ground of title. The appeal was allowed on alternative claim made by the plaintiff of that suit on the ground of adverse possession. On the ground of adverse possession against the state, acknowledging that because the vendor had already been...
There were two plaintiffs in 2004 suit. Then in
Yes.
whose favor the adverse possession was declared? Plaintiff number 1?
Yes. This is important. The concluding portion of the appellate court's order. Because the relief claimed was, the relief may kindly be seen for a decree of declaration title of plaintiff number 1 Sayyid Istiaq Ali over the suit property. And the decree by the trial, by the appellate court was, thus in view of the discussion made above as above, on the basis of materials on record, it has to be concluded that the plaintiff succeeded in establishing the fact that they perfected the title over the suit land by way of adverse possession, and as such are entitled for the decree as prayed for. As prayed for, and what was prayed for was for a decree of declaration of plaintiff number 1 side, not plaintiff number 2 Nutan. So this was the relief that was granted by the appellate. Now what happens? On 27/4/2010, Sayyid Istiaq Ali executes sale deed in favor of his son from the first wife, that is the dependent appellate hearing. By registered deed, he executes a sale deed in favor of defendant number 1, Mubi Ali. Now that led to filing of the suit by Nutan in the year 2011. And this is the suit that we are now dealing. This is the second suit. Now I'll pray if the Honorable Court would kindly take up the claim, because I directly want to show what was the relief claimed in that claim, that because there are certain typographical error in my list of dates which are given in the second claim. But the reliefs that were claimed was for declaration of title of plaintiff, that she is the owner of the property, and for declaration of cancellation of that these 3 sale deeds executed by Sayyid Istiaq Ali in favor of the dependent is null and void. And the
In
same
the
may be declared
counterclaim,
as
you
null.
did not pray for a declaration of your title. You only claimed for a recovery of possession.
My suit.
Your
my
counterclaim.
I'll come to that. Now, the plaintiff files a suit praying therein for two reliefs: for declaration of the right title interest and for cancellation of the sale deed which was executed by Shayyad Ishtiaq Ali in favor of Mubina. So, now what would be the consequence of it? That now the trial court dismisses her suit and the plaintiff, both these claims were disallowed by the trial court and the plaintiff has not filed any appeal whatsoever. So the consequences would be that there is no declaration of title in favor of the plaintiff and the sale deed have not been declared as null and void. The consequence would be that they still exist as on date and they are registered deeds executed by a person who was the owner of the property. And having no appeal was filed, so the consequence would be that my sale deed still stands and I would be the owner of the property. So my only prayer was for recovery of possession because my sale deed was still existing. I was not required to seek further declaration of my right title interest. So once the suit of the plaintiff failed, my suit was liable to be decreed, which has not been done by the trial court.
Trial court must have rejected your counterclaim by citing some reason.
Yes.
What is the reason of rejection of your counterclaim? What is the reason for rejection of your counterclaim?
The relevant is page 23.
You must have paid the required court fees for the counterclaim.
Yes. All those are not in dispute.
This is at page number, internal page 29.
Yes. One thing, if the Honorable Court would kindly see the decree portion of just after the judgment. On both sides, the stamp for complaint have been filed. That means the plaintiff also filed and we also filed. This would be in the second page of the decree. At the bottom, cost of the suit. The first is stamp for complaint, 50 rupees, and on the right side also, by the defendant, stamp for power 50,000. So maximum court fee was paid by both the sides. Internal page 19 would be relevant because there, what were the issues that were framed by the trial court that would be relevant. It starts from internal page 18. These were the issues that were framed.
Okay. Roman 14. Whether the defendant is entitled for a decree of recovery of possession.
Yes.
This is the only issue with which we are concerned.
I'm reading all the issues and then it would be better for
the others need not be there because the suit will be dismissed. So the point is whether you are entitled for the recovery of possession.
Yes.
So what is the finding?
He starts discussing and from page 23 and the conclusion with regard to the plaintiff's case is at page 26 and then the discussion with regard to our case is there in para 12. I'll just read the concluding portion of page 25. After considering all the facts and circumstances discussed above, in its totality, the court has no hesitation to reach on its conclusion that preponderance of probability is not in favor of the plaintiff in this case, hence it is collectively held both parties in negative upon by holding further that the suit as claimed is not maintainable in so and so, accordingly the issue is decided in negative against the plaintiff. Issue number 5, 6, 7, so and so, all these are now collectively decided, and all these issues have been mentioned in para 12, whether the suit property is purchased out of income of Sayyid Ishtiaq Ali, whether the deed of release executed by plaintiff in favor of Ishtiaq Ali is valid or not, whether Ishtiaq Ali was the absolute owner of the suit property or not, whether the sale deed bearing number so and so dated 27/4/2010 is valid or not, whether the defendant acquired title on the basis of reports in sale deed, whether the provisions of CNT Act are applicable to the suit, whether the plaintiff is a licensee under the defendant or not, whether the license of the plaintiff was revoked by the defendant on 28/2/2011, whether the defendant is entitled for recovery of possession of the suit premises by evicting the defendant thereof, and to what relief. And then I may be allowed to read further in this page itself, because it is only a few pages. This finding I may be allowed to read in entirety, because here he is rejecting my conclusion. Defendant in counterclaim claiming his right to interest over the suit property on the basis that the suit has been purchased by Sayyid Ishtiaq Ali, who is the absolute owner of the land. If we analyze the document,
the suit property has been purchased from the defendant that purchased the suit property from Ishtiaq Ali.
There is the defendant who is the son of Ishtiaq Ali who purchased it from Ishtiaq Ali.
Yes, please continue.
Yes. Interest over the suit land on the basis suit land has been purchased from Ishtiaq Ali, because I was claiming on the basis of sale deed executed by Ishtiaq Ali, who is the absolute owner of the suit land. If we analyze all the documentary evidence and the oral evidence led by the defendant, we will come to know that defendant has produced a sale deed dated 27/4/2010, which shows that he has purchased this suit land from Sayyid Ishtiaq Ali. Defendant has also produced deed of relinquishment, which shows that plaintiff has relinquished his, it would be her, all right, title, interest over the suit land on 25/1985. If we go to the judgment passed in title appeal number 23 of 2007, this is previous round of litigation, which para 10, which is as follows. As is obvious, the plaintiffs claim themselves to be the title holder by way of adverse possession starting from 1960, when the vendor of the plaintiffs purchased the suit land from Akhil Chandra Rai. The said sale deed has been executed by Akhil Chandra Rai in favor of Jwala Prasad Singh, the vendor of the plaintiffs, on 16/7/1960. Upon the said Jwala Prasad came over the suit land, and then 10th of January 1985, the said Jwala Prasad Singh executed the said sale deed in respect of the suit land in favor of plaintiff number 2, who subsequently on 25/1985 executed a deed of release in favor of plaintiff number 1, her husband, relinquishing her right, title, interest with respect to the suit property in his favor as stated above. It has been said that right from the date of purchase, the plaintiffs remained in peaceful and continuous possession of the suit land. As far as the divisional survey Khatian is concerned, admittedly the suit land is recorded in the name of Bihar Sarkar, and the illegal possession of Jwala Prasad Singh, vendor of the plaintiff number 2, is shown in the Khatian since 1970, and the said Khatian was finally published in the year 1979. Assertion of the plaintiff is that, assuming that the Akhil Chandra Rai having no title over the suit land, at least he can well be taken to be a trespasser in the same way. Subsequently, Jwala Prasad came in possession of the suit land through Akhil Chandra Rai as a trespasser, and pursuant to the transfer made by him in favor of plaintiff number 1, came in possession of the suit over the same as trespasser in continuity. And in this way, the possession of all three trespassers is tracked together, and the period is counted from the beginning, from 1960. Then it can be easily concluded that the plaintiffs have perfected their absolute right title over the shoot land by way of adverse possession. It is clear from the judgment that the plaintiff has perfected his right on adverse possession after a lapse of 30 years. If we calculate the 30 years period from 1960, it comes to 1990, meaning thereby plaintiff has perfected his right title interest over the shoot land in the year 1990 by adverse possession. Then the question arises in fact of relinquishment, which is being done by the plaintiff in favor of Sayyad Ishtiaq Ali. How is it possible? The title which is being perfected in favor of plaintiff in the year 1990, that a title is being relinquished in 1985. The right is not in existence on the date of relinquishment. Learned counsel for the defendant has raised the plea that the deed of relinquishment is binding on the plaintiff. So far as the defendant is concerned, it is legal proposition that no one can transfer a better title he having, since in the date in which the suit in the deed of relinquishment has been executed by plaintiff with regard to the title, that right is not in existence, because that right is being perfected by adverse possession and the order of the court in the year 1990. Moreover, if we go through the sale deed in the year dated 27/4/2010, this is the sale deed executed by Ishtiaq in favor of, in which page 4, which is as follows. And whereas in the year 2007, the present vendor decided to sell his property, which he discussed with his family member and sons, that is Sayyid Mubin Ali, has told his father Sayyid Ishtiaq Ali at the time to hold the house property to me, Sayyid Mubin Ali, rather than selling it to some third party or person. And the present purchaser offered to pay the same amount, which is the highest consideration in the year 2007, to which the present vendor and his wife, namely Sultan Ali, wife of Ishtiaq Ali, agreed for the same. And thereafter the purchaser told the present vendor that he will pay the consideration money in installment, and then as and when required by the present vendor, that is Ishtiaq Ali, whenever he needs money. Further, if we go through para 6 of the counterclaim, which is as follows, that the license was revoked by defendant on 28th of February 2011, and they orally communicated the same to the plaintiff, requesting her to vacate the suit premises within 15 days. In spite of the request made by the defendant, the plaintiff failed and neglected to vacate the suit premises within 15th of March 2011 and gave threat to the defendant that she is in touch of superior police officer and other local leaders of so and so and so and so. And she can, at any point of time, can throw the above person from the house. If we analyze both the fact mentioned in the counterclaim and mentioned in the sale deed, both the facts cannot coexist together. In one hand, the pleading of the counterclaim of the defendant has stated in this fact that the suit land is being licensed to the plaintiff. On the other hand, during the sale of the suit land, it is clearly mentioned in the sale deed that Sayyid Ishtiaq Ali and his wife, namely Sultan Ali, were agreed for sale of the suit land. It is settled principle of law that the intention of the party during the sale of any property is clearly drawn from the averment made in the sale deed only, and the averment made in the sale deed is clearly shown that both Sayyid Ishtiaq Ali and Sultan means were agreed to sell the suit land. If plaintiff Sultan Ali was the licensee, then there is no requirement of her consent in the sale deed of the suit land. But at the same time of sale of the suit land, vendor as well as vendee has also accepted this fact that consent of plaintiff Sultan Ali is necessary. It is pertinent to mention here that although the consent of the plaintiff Sultan Ali has been taken, but the signature of Sultan Ali has not been taken on the sale deed. Therefore, on one hand, defendant claiming that the plaintiff is licensee, on the other hand, he has taken the consent during the sale of the suit land are contradictory to each other. So far as plea of learned counsel for the defendant that possession of the plaintiff over the suit land in capacity of licensee is concerned, defendant has not cleared his possession. In one hand, he is mentioning this fact that the plaintiff is licensee, and on the other hand, the consent is being taken during the sale of the suit land. After considering all the facts and circumstances, in totality, the court has no hesitation to reach its conclusion that preponderance of probability is not in favor of defendant in the counterclaim, hence it is collectively held. And so now ultimately the trial court dismisses the suit as well as the counterclaim.
So far as this, any connected appeal has been filed by you? No. That is an admitted fact that no appeal has been filed by the plaintiff. Mr. Gupta, so far as this counterclaim is concerned, the entire discussion is referring only to the documents. Is there any need to refer to any oral evidences on this, or there is no need? According to
No, not required.
Not
because of the effect of the non-filing of appeal by them. So most of the things are crystallized. Now I'll beat out the two reasonings which have been given by the appellate court, by the trial court. Now here the trial court is making out a case which is not even needed by the party. It is not a list against the state. Now state's list has already been decided that the suit was decreed as prayed for, and what was prayed for was declaration of title of plaintiff number 1. So once that was decreed, and even if it was done subsequently also, and the deed of release was in prior in point of time, let us assume that she did not have the right on the date when she was executing a deed of release. Then also, even if a person executes a document and subsequently he gets the title over the property, then he cannot back out from the document which has already executed. So that would still be binding on the person. So this is probably section 14. If a person has an imperfect title and executes or transfers certain property, and subsequently if he acquires right over that property, then the vendee would have the entire right over it.
This is section. Which section is this?
Yes, 43. Transfer by unauthorized person who subsequently acquires interest in the property transferred. When a person fraudulently or erroneously represents that he is authorized to transfer certain removable property and professes to transfer such property for consideration, such transfer shall, at the option of the transferee, operate on any interest which the transferor may acquire in such property at the time during which the contract of transfer subsists. So here there are two deeds. First is by Jwala Prasad in favor of Nutan Mij, and then Nutan Mij in favor of Sayyad Istiagar. So both professed that they had the title over the property, but subsequently, by whatever reason, that title has been affirmed by the appellate court in previous litigation against a third party, against the state. So even if it is taken that they had imperfect title, then by virtue of the decree passed by the appellate court, that was, the title became absolute of Sayyad Istiagar. And here, this was not a case against the state. Against the state, our case was absolutely final. The court could not have made out another case which was not even pleaded by the party.
Which all exhibits do we need to look into?
Yes,
Give me the list of exhibits which you would like to place.
yes. I have also prepared a note, written submission, but there are certain typographical errors. I'll file it within a day or two.
Which all exhibits do you want to refer to?
Yes. Relevant would be exhibit, the sale deed and exhibit.
Just give me the exhibit number.
Yes. This is exhibit 2. One also, because this was the original sale which was in favor of Jwala Prasad Singh. And then Jwala Prasad Singh executes a sale deed by exhibit 2 in favor of the plaintiff Nutan Mehta.
Yes.
Then the third would be exhibit 7. And then the defendant's case, exhibit G, G by 1, H by 1, and exhibit I. H and H by 1 are the original suit which was initially dismissed by the previous in the previous litigation. But main exhibit would be exhibit G and G by 1 and exhibit I.
H and H by 1 should I delete?
H and H by 1, the
Let it be there to sequel.
Okay. But ultimate conclusion is binding order is exhibit G and G by 1. This is all. And second point also, which the appellate court, this trial court has said, that in my sale deed, it has been mentioned that Nutan Mehta had also consented to transfer. Although we are on one hand, we are saying that she is a licensee, but in sale deed, her consent has been mentioned. But even if her consent has been mentioned, but if she was a licensee and we make an additional statement in a written statement that she has also consented, that would not make the sale deed a void of.
Sale deed is not void because sale deed has not been declared to be void.
The
court in the counterclaim is also not saying that the sale deed is void. Has the court said that the sale deed is void? No?
No, it says, it does not, it says, so why it is rejecting my, that is the one of the reason that it is saying that it is not relying on my sale deed. That is the reason. What it says is, page 30.
Yes,
This here it is this discussion with regard to my sale deed. If we analyze both the fact mentioned in the counterclaim and the sale deed, both facts cannot coexist together because we were saying that she was the licensee. So, in one hand, in pleading counterclaim of the defendant has stated this fact that the suit land is being licensed to the plaintiff. On the other hand, during the sale of the suit land, it is clearly mentioned in the sale deed that Sayyid Ishtiaq Ali and his wife Nutan Ali agreed for sale of the suit land. It is settled principle of law that the intention of the party during the sale of any property is clearly drawn from the averment in the sale deed only, and averment made in the sale deed is clearly show that both Sayyid Ishtiaq Ali and Nutan Ali agreed to sell the suit land. If plaintiff Nutan Ali was the licensee, then there is no requirement of her consent in the sale deed of the suit land. But at the time of sale land, vendor as well as vendee also accepted this fact that consent of Nutan Ali is necessary. This is unnecessarily the trial court has made out of it. If certain additional statement is there that my wife is also consented,
So what? How does this make my deed or affect my sale? Because ultimately Sayyid Ishtiyaq Ali is the person who is executing the sale deed. And the challenge to the sale deed fails by the person who is mentioned as the licensee. When the trial court ought to have then at least decreed the plaintiff's suit, here he disbelieves the plaintiff's case and dismisses the suit, and then
The trial court has held that the plaintiff do not have the title. But at the same time, while rejecting the counterclaim, the court says that the plaintiff is the licensee. Right?
yes.
And if the court says that the plaintiff is the licensee, then under such circumstances, your deed is not in dispute. But so far as recovery of possession is concerned, then appropriate steps in
he does not say that. He does not say that there could be no appropriate step, because this is the suit
the license
itself
is
that is the
required to be
appropriate
revoked.
step.
The license itself is required to be revoked to evict them.
I have done it. Prior to filing of the suit, I have issued a letter and I have said that you please evict. You are there in the property as a licensee, and then on the basis of that fact, I have filed the counterclaim that I have revoked my the right of licensing.
Which is
I have
that
revoked
exhibit?
the license.
Which is that
And-
exhibit?
Yes. That only portion I'll point out. Yes, it is mentioned in page, internal page 13. This is not a written notice, but last paragraph. Defense third contention is that, in the counterclaim is that, the license was revoked by the defendant on 28/2/2011, orally communicated the same to the plaintiff, requesting her to vacate the suit premises within 15 days. In spite of the request made by the defendant, the plaintiff failed and neglected to vacate the suit premises within 15/3/2011 and gave threat to the defendant that she is in touch of the superior so and so and that she can throw so and so.
Without a written notice, how can it be taken that the license was revoked? Your oral submission. How the license can be orally revoked?
There is no requirement of written
you-
revocation because
She is not a
license
trespasser.
was also
As per the sale deed and the arrangement, whatever be it, and as per your documents also, she is not a stranger. She is a licensee.
licensee, but there is no document of license.
Need not be, but that was your
If the
case.
document of license would have been a written document,
That was your
then
specific case that she is a licensee. Even for being a licensee, you don't need a written document. You need a written document. Not necessary.
For both purposes.
But for the purposes of revoking the license under the Transfer of Property Act also you need to give a notice.
No, that is your lordship is referring is lease, not license.
Even for license, some notice has to be there, written notice. You orally say and she orally says, and how does it come?
There is no requirement of issuing a written notice, because written notice is there only in section 106 of the Transfer of Property Act, which only deals with lease of the property.
How is the license revoked? Under the provision of Transfer of Property Act?
In licenses, it is absolutely the property of the licensor.
That's right.
Person
There is no doubt that the property belongs to the licensor. But the point is that how do you revoke the license? What is the process to revoke the license? There has to be a procedure somewhere. Licenses are being revoked. Legal license. How is the legal license revoked?
License could be that I am permitting a person to. I'll continue this further tomorrow, because there are certain judgments where the Honorable Court has differentiated between what is the difference between a lease and license, what are the effects of a license. So it would be better that we see that.
Because admittedly there is no document by which you have revoked the lease, the license.
Yes.
You make an oral statement and then you say that she is in touch with the government officials, right?
Well, she is saying that
She is in touch with the commercial, in the government officials or police officials, and she refused. So that becomes your cause of action to file a counterclaim.
That would be because she is now denying my title. She is challenging my safety.
She denied your title. She challenged everything, right?
Yes.
But your case was she is a licensee.
And
admittedly she is in possession of the property.
Who would be a licensee? A person.
You are the licensor now. You are the licensor by virtue of the judgment also, because you are the owner of the property now.
I am the owner of
title
the property.
Holder, you are the title holder of the property and they are in possession.
Yes. So if I am allowed that person to be in possession of the property, then that person becomes my licensee, because I am allowing that person. So the moment I revoke that right,
What is the modus to revoke a license? Is this kind of an oral statement sufficient, or something more was required?
Because no written document is required for creation of a license, or nothing written is required for revocation also.
Not necessarily. It is not so straightforward.
No,
it is not so straightforward.
If there would be a case that a person is being put in possession on the basis of a written document, then there can be a case that a written document is required for revoking the license.
This is
But
important. Because although there is no document of license, but you admit that there was a license because there is a recital in your sale deed itself that she is a licensee. There can be a sale deed. You see, there can be a sale deed.
That recital is not there, but
it may not be. You see, the court has recorded. The court has recorded that there is a conflict and contradiction. And even if we assume that there is no conflict and contradiction, then under such circumstances, your status that you are the licensor is not in dispute, even as per your counterclaim. So revocation is the only thing which we have to see, that whether you have revoked the license.
I'll answer to that. That is the only point of law that would now.
Yes. Dr. Natal.
I was playing for Thursday.
Do it tomorrow. What should this appoint? Right? Find it out what is the mode and manner of revocation.
With respect to that title appeal, that only title was claimed exactly by.
You work it out. You work it out. But tomorrow you have to continue.
Yes, I'll answer to this.
And whatever you have submitted and these sequence etc. kindly put it in your note and furnish tomorrow. You are coming
Yes.
to the court tomorrow or not?
Yes, I'll join. I'll join online lecture tomorrow.
You are not in Ranchi?
For that matter itself, I'll come to the Sahara matter, which your lordships have. Now it has reached the end stage, therefore I have.
What is the date fixed over here in Sahara?
Next month, 16th of April. But the records have to be sent by 4th of April.
The hearing of the case has commenced. It appears that the suit was dismissed and simultaneously the counterclaim was dismissed. The learned counsel for the appellant has submitted that the suit having been dismissed and no appeal has been filed, the plaintiff certainly does not have title over the property and the deed which was under challenge stands, and therefore there was no occasion for the learned court to dismiss the counterclaim. The counterclaim was filed seeking recovery of possession of the suit property. During the course of hearing, it transpired that the plaintiff, that the defendant had asserted that they have revoked the license orally. To this, the learned counsel for the appellant has submitted that he shall advance his further arguments tomorrow on the point as to whether the license can be revoked orally. Post tomorrow, as the court time is over, post tomorrow for further hearing. कल एक थोड़ा सा नोट बना के
बना हुआ है, लेकिन वही पूरा
एक चीज और ड्यूरिंग द कोर्स
लेकिन आप फाइनल आर्गुमेंट के हिसाब से थोड़ा बहुत कुछ चेंज करना पड़ेगा।
ठीक, कोई बात नहीं। ड्यूरिंग द कोर्स ऑफ हियरिंग
एक फाइल कर दे रहे हैं, फिर जैसा
during the course of hearing he has submitted that there may not be any necessity to go into the oral evidence and the documentary evidences which may fall for consideration to decide the counterclaim are exhibit 1 to 7, T on in here 1, 2, 7 and exhibit G, G by 1, H, H by 1 and I. That's all.